5, 4.
Welcome back. I am very excited to introduce our next guest. Richard A. Luthmann is an esteemed attorney here on Staten Island. He has made it his personal agenda to be sure all of us here on Staten Island, and in New York as a whole, are aware of what he himself has referred to as foolish allegations being brought against him. Currently being called the trial by combat attorney by Fox and Friends, the New York Post, SI Live, and many other major media outlets. He's here today to share his story with us. For those of you who are not aware what I'm talking about, the next 22 minutes should be very, very informative. So now, without further ado, I am honored and privileged to introduce to you Mr. Richard A. Luthmann. Come on in. Welcome. Thank you so much for being here.
No problem.
Please have a seat. Okay. So, for those of my viewers who aren't aware of your story and what's going on in your life right now and all of the media excitement, can you just give them a little bit of background about what's going on? And
Sure.
Go ahead.
So I'm a lawyer.
Right.
And I represent all sorts of people. And one of the people that I represented, it was actually a company. It was a financial company. A Manhattan-based, a New York-based financial company. And they were basically sued by a Connecticut company.
Okay.
And so, you know, not to get into all the details of the case, but I was working as tax counsel and as a transactional counsel at the time, and for a period of about 6 months prior to the lawsuit. And there was a lawsuit that was commenced, and they got a judgment against the company and its principal for, you know, $500,000. And so, you know, they try to enforce the judgment. A year, 2 years go by, and they come up empty. And so then they turn around and they say, oh, well, let's now sue the lawyer. So these idiots are coming at me, the lawyer, which it really has no basis in law. I'm very, very upset with them, but not so much them as much as their attorney. Because I think the guy slept through law school the day they actually taught law. You know, really, it's just idiocy. It's like I'm representing you know, someone who gets convicted of murder or life in prison, and the guy jumps bail, and then they're going to put the lawyer in jail? You know, everybody understands that the lawyer and the party are two separate people. And so their allegations against me they're misleading allegations as well. It's something called a fraudulent transfer. And a fraudulent transfer is not fraud, as we understand. All that fraudulent transfer means is wrongful transfer, a transfer that happened that shouldn't have happened. Fraud is an intentional activity, misrepresentation, and that's very harmful to the reputation of any business person, let alone an attorney, that an attorney committed a fraud. And even some of the media outlets that are out there have said, oh, Staten Island attorney accused of fraud. Well, there's no accusation of fraud here, and a lot of them put in retractions, which was very professional of those media outlets. But the fraudulent transfer is just a wrongful transfer, and they're trying to say that I aided and abetted, or I conspired, or I owed some duty to these individuals to make sure that my client didn't engage in fraudulent transfers. So their claim is that there was money that was available in the company at a certain point, and then that money was no longer available, and it's all my fault. And their biggest sticking point is that the client, the company, paid me a legal fee. I'm working for the guy, so evidently they think I want to work for free as well. So I'm in court with these people, and you know, if I was really a bad guy, if I really had done all the stuff they said that I did, why didn't they bring me in the very beginning? You know, when they sued you know, the company and they sued the principal, you bring me in the beginning. Oh, Luthmann's along with a lot of them. He's in conspiracy with them. He's aiding and abetting them. That's they didn't do that. Number one. Number two, I have no obligation to them.
Right.
You know, I have an obligation to a client, and I have an obligation to a legal duty, but I owe them no duty. I'm basically a competitor of theirs in the sense that, as a lawyer, I'm a creditor of this guy, and so I had a bill that needed to be paid, and so they're trying to jump in front of me and trying to get me to give back money that I've earned.
Right.
So it's purely, it's disgusting, really, and that another attorney would be involved in this, and we're going to take action against him, and so he basically, you know, I combated their complaint with what's called a motion to dismiss.
Okay. Okay, which is fair.
A motion to dismiss is says, look, Judge, before I even dignify this with an answer, Judge, I want this case just to be dismissed. It has no basis in fact or law. The allegations they made in this case are that I, as an attorney, owed them some obligation more than the morals of the marketplace. That's actually the words of a very famous legal decision by Justice Cardozo, Meinhardt v. Salmon. And there's something called the morals of the marketplace, and that's the market. And basically anything goes, absent harmful actions like fraud or things like that. In the market, it's caveat emptor, buyer beware, and it's really a race in time. Between creditors, between other people. If you get there first, you're there. If you're not, too bad, so sad. If you can enforce a judgment, you enforce it. If you can't, you can't. They're trying to impute a duty. They're trying to say that I did this, that I did that. And so I put this motion in to say, Judge, just throw this case out. It's a waste of time. I didn't even ask beyond that. I did ask for sanctions. I think it's a frivolous lawsuit. I think there's a lot of too many frivolous lawsuits in the commercial division. People are just trying to get money. This is nothing more than a money whack. They figure we can't get our money from the clients. Let's go after Luthmann. Maybe he'll cough up $10, $20, $50,000. Either him or through his insurance. And I said, I have insurance, but I didn't do anything wrong.
Right.
I'm not going to do this. I'm not going to put this in and raise my rates. I'm not sure raise everybody else's insurance rates. I'm going to fight these idiots. So I did it the way that I know how to do it legally with a motion to dismiss. Well, they come back at me and file a cross motion to my motion to dismiss. And what their cross motion said was, we're going to cross move to tell the judge, to tell you, Luthmann, that you can't sue us for abuse of process, for malicious prosecution, to try and get money from us for all the time and costs that you're wasting dealing with this lawsuit if it's proven to be frivolous. You can't come back at us. That's what these people said back to me. So at that point, we're outside the system of law. They're telling me I can't use the legal system to go back at them to get money to recoup my time, recoup my costs for a frivolous lawsuit. So I say to myself, you know what? This is ridiculous. It's absurdity. But I'm going to give them back something that, while as absurd as it sounds, still has a basis in law. And that is trial by combat. Now, this is something that I have been thinking about for several years. I'm a huge Game of Thrones fan, and I think it was 2013 that we saw our first trial by combat, maybe in 2012, in the Game of Thrones series. I had read the books before that. And so I understood the part of medieval history and Anglo-Saxon and Germanic tradition, and even part of many continental European cultures. And I did a lot of research at that point. And then when this happened with this case, I said, this is the perfect time to take this out, trial by combat. So I asked the court for something that I believe has a legal basis in the law that is still on the books, and that is I want a judicial duel. I want the court to sanction the ability for me to go, me or my representative to go and duel these people or their representatives. Okay, and that's what I want. Now, this has a legal basis, a very, very clear legal basis, because all throughout medieval history and up until the time of the Revolution, judicial duels were sanctionable. British magistrates had the ability to sanction a judicial duel up until that point. It was still on the table and on the books. When we declared our independence in the state of New York in 1776, there's part of our New York Constitution, that's Section 14 of the Constitution. That section says that everything that was on the books under the British common law is now part of New York law. So there are two bases under state law that I believe that there is the ability for a judicial duel to be sanctioned. Number one, it was never specifically outlawed by our legislature. So there was nothing that said there's no ability to have a judicially sanctioned duel. There was a prohibition against dueling by prior agreement, which is what we all remember from the Alexander Hamilton and Aaron Burr situation. They had a duel by prior agreement, and that is a criminal activity. But this would not be a duel by prior agreement. This would be judicially sanctioned. So that, to my legal interpretation, is still on the books as far as something that I can request in court. Number two, Section 14 of the Constitution also has in it the fact that not only the legislature but the judiciary. We had British magistrates prior to the Revolution. Then afterwards we have justices. We have justices of the Supreme Court now. And it's my argument and contention that irrespective of what the legislature does, it would take nothing short of a constitutional amendment of the state constitution to remove the inherent powers of a Supreme Court justice to order a judicial trial by combat. And so that's, goes to the very heart of our state constitutional structure. Because you can think about it, Supreme Court justices are elected officials. They're elected to a term of office. And so you could conceivably have an individual who is a Supreme Court justice, or running for Supreme Court justice, running on a platform of, if you elect me to the bench as a Supreme Court justice, I will entertain applications for trial by combat. If you make a motion in front of me, and you want trial by combat, I will entertain it. If you have both sides agree that you want a trial by combat, I might even sanction it. As a judge that could run in the state of New York in an elected position, that is totally permissible under our Constitution. Because there has been no amendment by the people, the sovereign people, to change that. The third basis of law is the federal law. We have a Ninth Amendment under the Constitution. The Ninth Amendment reserves rights to the people. This is part of our reserved rights to the people. So the federal government couldn't come in and take away this right that's textually committed insofar as it was part of the law, and there was even a real movement in 1774 to outlaw and abolish trial by combat in the British Parliament, and that was defeated. So we have clear evidence in the legislative record of the British Parliament 2 years before the Revolution that says this is part of the law. This is something that you can do. This is something that must be sanctioned, obviously, given the law, but I'm doing what's proper. I'm asking the court, I want to go in and I want to duel these people. I want a trial by combat. When you think about it, it makes perfect sense because in today's day and age where discovery costs so much, and it's time and effort and court resources, this is judicial economy. I'll meet the guy, pistols at dawn, whatever they want to do. If they want to go with swords and shields, we'll do whatever they want to do. And this will be, it'll be done. We'll be done very quickly, and we'll have our trial done. It'll be over. Instead of waiting 2, 3, 4, 5 years, we'll get it done.
So this is amazing to me. I've been following your story for the past few weeks. I'm blown away by all the facts, just the way that you're not doing this frivolously. You're making sure that you're taking the right channels, you're doing the right things. And you actually said that you may be upsetting some people. Maybe this is a little bit controversial. How do you feel about what you're starting off now and what you're starting?
Well, the fact of the matter is this. We have a tradition in America where the people are the sovereign. Sovereign people. And the fact is, when you have rights, the rights are there, but the rights that we have under our Constitution harken back to an age where honor was a value that was treasured. And the fact is, my honor has been besmirched.
Right.
My business reputation has been hurt. People think that I aided and abetted a fraud. A frivolous lawsuit has come here that I have to spend time and money to go against. And these people have basically insulted me in my business reputation. And there's no measure that I'm ever going to be able to get back from these people. I can't sue them for defamation or libel because there's basically a litigation privilege. When you make an allegation in a lawsuit, then you have a privilege in the lawsuit that you can't be sued for libel or defamation. But there are other things they're doing. They're abusing the legal process. There's malicious prosecution. There's this. But the fact, at the end of the day, do I want a check? Is a check going to do anything for me?
Right.
It's a consolation prize in the sense that, okay, fine, they did this, they did that, and I show that I'm right. They're writing me a check. But that's not going to stop everybody out there from thinking, Luthmann this, Luthmann that. The best way to do it is to defeat them. To defeat them, to put honor on the line, and to say, I am ready to put my entire honor on the line, either myself or by way of a champion, which is my right, and I'm going to take you down. I'm going to take you out. So we'll see what happens because there's many different types of trials by combat. It could be, back in the Germanic tradition, they used to have wooden shields and wooden clubs, and they'd beat each other up. They'd have two champions beat each other up until one was quote-unquote too damaged to continue. So it could be that, it could be, an MMA fight. It could be pistols at dawn. It could be any other type of trial, be a joust. Who knows what it could be, what the nature of this could be, whether it's by agreement, whether it's by court decree. But the fact is, I don't think a trial based on evidence at this point is really going to matter. Because it's not about evidence, it's about honor. I didn't do anything wrong. And the fact is, I'm so sure in that I'm willing to make the ultimate risk. That's where I am.
It's amazing. I think what you're doing is so commendable too, because you're showing, like you've used the word foolish in the past in other articles too I've seen, and you're bringing the light. You're showing people how you really feel. And I have to say, that's honor right there, And because I know you a little bit more on a personal basis, I can't see these allegations being true at all. I'm like, and like what you said, it's horrible that it's putting your reputation on the line.
It's absurdity. It's absurdity that they're doing. And to the extent that people may say that Luthmann is absurd in doing this, everything that I have has a basis in the law. Everything that I'm talking about here. And it has far greater basis in the law than what Mr. Cusid and what Mr. Foley and what Beachdale Capital and what all these idiots out there are trying to allege in this case. They are just idiots for trying to allege it because it has no basis in fact or law. It is beyond frivolous. It just has no merit whatsoever. And it makes me very, very upset, that people are running around like this. And that's why I said, the lawyers should know better. And the lawyers should know a lot better. And he's the guy that's probably the biggest idiot out of the bunch. I don't know if his practice is doing poorly, that he needs to take a case like this. I don't know his personal circumstances. I'm not going to even speculate. But the fact is, I think he fell asleep in law school when they taught law. What are you going to go? It's so, like the person on the street, the housewife knows that this is something that you can't do. And so this is at a point where I hope that I can turn lemons into lemonade and let people start to see that these frivolous lawsuits in business are hurting everybody. In the sense that I'm a business owner, I'm a lawyer too, but I can even see that, what is this? This is just a whack at insurance money. This guy thought he could throw this in the groove, and the insurance company will say, okay, well, it's going to cost us $10,000 or $20,000 to try to defend this a little bit, to put in some motions and do a deposition. We'll just pay the money to these guys, 10, 20, 50, whatever the number is. And this happens every day. This is why our insurance costs are so high as a business owner. I don't know how business owners, do it anymore. And I don't know how people put their head on the pillow at night with all the risks that are out there in business. That the insurance costs are so high, and then you have to run around and everybody's looking to sue you and everything else. It's crazy. So I think there should be some type of legal reform here where you actually have some rules that have some bite. In the federal system, there's Rule 11 and will sanction you pretty quickly. I think that they should have Rule 11 type sanctions in the state courts and the commercial division. We have great elected officials on this island, and that's something I think they should take a look at. I'm not talking about normal cases. If someone gets injured in an accident, if somebody has some type of harm done to them, you should have as expansive as an ability as possible to bring a claim. People should be able to make themselves whole insofar as to recover from a personal injury. But when you have a situation where these people are claiming a baseless business type commercial transaction, it's two businesses and it's an insurance grab, then the lawyer and the parties should be held responsible for milking the insurance system. Because all this is going to do is raise insurance costs for everybody. Everybody wonders why insurance premiums go up and up and up. You can do nothing wrong when your insurance goes up. Think about it. This is basically, on the same level as insurance fraud in my mind. This is the same level as insurance fraud. They're trying to milk the system. So, and this gets me very, very angry.
Yeah, I can see that. But it brings, I guess, to light how important the topic is for you and what's going on, and how you're a huge advocate of the community. Also, you're out there, you're fundraising for companies, and you're an honest businessman. So for this to be attacking you, it's not right.
And I think it's a disgrace. It's a disgrace. And, you know, I'm going to fight this thing, and we'll see what happens. I have court coming up in front of a judge here in Staten Island, an excellent judge. She does a great job, and she writes reasoned opinions. And I want her to take a look at this, and I want her to resolve the case. I'm happy with the case going away. I made my point about the absurdity with trial of combat, but the other part about it is, if I have to take this to the top levels, if I have to go there and I have to put my money where my mouth is and take this to the Court of Appeals, which I was at earlier this week, the New York's highest court in Albany, or even to the Supreme Court of the United States, I'll do that just to prove my point. I will do that.
That's what I was going to ask you. I was going to ask you where in the process you are right now. So you're waiting to hear back from this point?
We're early on, where they filed the complaint, and we went back and forth procedurally. I haven't even answered their complaint, because I don't believe I have to answer a complaint. I don't have to dignify their complaint with an answer. That's what I've asked the court. I've asked them to dismiss this thing. It's rabble. It's worthless. And so we'll see what happens with the court. But instead of going through what we normally do with all the civil procedures and disclosure and this and that, let's just take care of this the old-fashioned way. You know, it's still on the books. You know, and the fact is, it's not just America where this is on the books. If you go to Italy, there are places in Italy where you'll have a car accident, okay? And the two men that get into a car accident, they can get out as a method of justice. They can get out of the car, and they could basically get in a fist fight. And then the winner of the fist fight pays for the damage on both the cars.
Wow.
Because the honor is so important. The fact that he defeated the other person, it's an honor to actually pay for the other guy's car. That's a system of justice. In southern Italy, in parts of Sicily, that's something that still happens. In Washington State, they have a system where you can really adopt, if both parties agree, to have a brawl. As long as there's a police referee, you can have a small claims case decided by a fight.
It's amazing.
You know, if people want to go to fight, I say let people fight. I'm ready to go fight. That's what I am. I'm a fighter. That's what I do.
So if this does come to fruition and it's trial by combat all the way, are we going to see you fighting yourself?
We'll see what happens. Most people don't understand this, is that I have, I played rugby for many years, and I have a replaced hip. I'm a young guy, but I have a total hip replacement. I have like a Bo Jackson injury when I played rugby. And so, maybe, we'll see, but that it puts me at a severe disadvantage. And under the law, people who are infirm in any way could have a champion. And in civil lawsuits especially, champions were always something that's part of the law. And so I want, to avail myself of the best opportunity to win, so I want to get a champion. And I've had a guy who, basically the Game of Thrones fan as well, his name is Jon Stark, the Stark of the North. And he's an MMA fighter, 6'3", he's cornered in the UFC, he's ready to go to bat for me. I have a good friend who is an Olympic fencer. And he said he would love to be my champion. I've had numerous people tell me that they want to be my champion. I have some guys from the Zimmer Club that said if we get this thing at Pistols at Dawn, they'll go be my champion. I have a few depraved individuals who want to shoot somebody to death. They love that opportunity. So, I have no shortage of people that want to come to my defense. So we'll see.
That's amazing. Well, I want to really, unfortunately we're out of time, and I wish we weren't, because I have so many more questions for you. But maybe we'll come and we'll see Richard Luthmann again, hopefully. So thank you so much for your time. Thank you for all the information. You have clarified so many articles I've read and so many interviews I've listened to on the radio as well. Yeah. It's been an absolute pleasure meeting you. And hopefully I'm going to follow you with the case, and all you guys can follow the case and learn more about it through the papers, through SI Live. Hopefully Fox and Friends again. You never know, right?
You never know. Never know.
Okay, well thank you so much for your time. Hopefully we'll see him out battling for that case, and I hope you win. I really do.
Thank you very much.
Okay. And thank you guys again for joining me for another amazing episode of Amanda on the Island. Until next time.
Okay, we're out.